College, WGAL, and the York Daily Record, Sunday News. I'm pleased to welcome you to the 2015 Judicial Candidates Forum for the York County Court of Common Pleas. I am Andy Miller. I'm the current president of the York County Bar Association.
I turned mine off. Go ahead. It'll be all right.
It'll be okay, Nancy.
I turned my mic off. It'll be
Okay. We'll see if this is any better. Again, my name is Andy Miller. I'm the president of the York County Bar Association, and we welcome you here tonight. Before we begin, we'd like to thank Harrisburg Area Community College for this wonderful venue that they've allowed us to use tonight. It's a pleasure to be here in the Arthur J. Gladfelder Community Room. Arthur Gladfelder was one of the founders of the York County Bar Foundation's Leave a Legacy program, which is a coalition of volunteers and nonprofit organizations and professional advisors that's still going strong today and that has worked together over the years to get the word out to York Countyans about legacy planning and estate planning and how it can support our nonprofit community. Art's legacy is still going strong today in all of the nonprofits and other charities that this program has supported over the years. And his civic interests were deep and wide, and the forum here tonight, I think, spreads his and transmits his love of the community and also the rule of law. I'd also like to thank all those who have helped to pull together the event tonight. Our Bar Association and Foundation CEO, Victoria Connor, who will be seated at the front. She's really done the lion's work to get ready for tonight, and we're very appreciative of that. Also, our committee members for the event, York County attorneys and fellow Bar Association members, Suzanne Greist, Bernie Ilkenoff, Anne-Marie McAway, Suzanne Smith, and our committee chair, the Honorable John Euler. Just a couple of other notes before we get started. We'd ask that everyone please turn off their cell phones or at least put them on mute. And if you do keep them on, you can post photos and comments using the Twitter hashtag #YDRJudge. And now I'd like to welcome and introduce our panelists and moderator for this evening. Our three panelists that will be asking questions are Scott Fisher, who is the editorial page editor and blogging coordinator for the York Daily Record, Sunday News, and YorkBlog.com. David Satterley, who is the campus dean, student affairs and enrollment management, the Harrisburg Area Community College, Central Pennsylvania's Community College, the York campus, and the Honorable John Euler from CGA Law Firm, retired judge from the York County Court of Common Pleas, York County Bar Association past president. We are also tonight supposed to have a fourth panelist in Pete Montaigne from WGAL, but unfortunately due to the events unfolding in Baltimore, he's been called away on assignment for tonight and can't be here. So we wish him and his news crew a safe evening as they cover the emerging events. Finally, I'd like to introduce our moderator for this evening, Dr. G. Terry Madonna, who will then introduce our candidates, review the roles, and keep us on track and on time for the evening. Dr. Madonna is a professor of public affairs at Franklin and Marshall College in Lancaster, where he is also the director of the Center for Politics and Public Affairs and director of the Franklin and Marshall College Poll. Dr. Madonna joined F&M in May 2004. For more than 30 years, he has taught and written about his two academic specialties, the American presidency and American political parties and political behavior. As a pollster in recent years, he has also written extensively about voters and voting behavior. He holds a PhD in political history from the University of Delaware. Dr. Madonna is also the founder of the Keystone Poll, which was started in 1992, which is the oldest survey produced exclusively in Pennsylvania. In 2008, the Keystone Poll was renamed the Franklin and Marshall College Poll, And in his capacity, he is the pollster now for numerous news outlets, both broadcast and print, across the entire Commonwealth. Dr. Madonna is also the host of Pennsylvania Newsmakers, a weekly statewide news and commentary program, and he writes a bi-weekly political commentary column called Politically Uncorrected, originally for CapitalWire.com and later for PoliticsPA.com. He is a regular analyst for WGAL and a regular panelist for WPVI TV's Philadelphia commentary program Inside Story. He's also a frequent guest on many talk radio programs throughout the state and the nation. Dr. Madonna has also received numerous awards and honors, and he is a recipient of the Distinguished Professor Award by the Pennsylvania Department of Education, the President's Medallion at Millersville University, and a special commendation for scholarship and leadership from the Board of Governors of the State System of Higher Education. In addition to this evening's event, Dr. Madonna has moderated numerous gubernatorial, congressional, state legislative, and school board forums, debates, and various organizations. So tonight we are pleased that he could join us, and with that, please join me to welcome Dr. Madonna.
Thank you. Can you hear me okay? And I'm not a candidate for anything. Thank you for that kind introduction. We all got it now?
Very simply, I'm going to get into the rules in a minute. Can you hear me?
It's now we're okay. All right, we're gonna, let me introduce the candidates and hold on a second. Testing 1, 2, 3, is that right now? It seems better now, okay. It's fairly interesting how we're doing these introductions. This is something that I've never heard of until tonight. The candidates are using 2793 elevator speeches. Translation, they have to be introduced in 27 words, which can be delivered in 9 seconds and make 3 points. You all got this? The other point as I introduce them is that we've all agreed we're going to use first names. These are community folks. Everybody, has a good idea who they are, and it'll be a little more informal, like a family gathering, which in many respects it is. So I'm going to start in alphabetical order. Carl Anderson, attorney Carl Anderson, a York native with only 30 years legal experience, including extensive trial work as a partner. Mike served as a common pleas judge in 2013 and 2014, end quote. N. Christopher Menges. Chris Menges is an attorney with Trinity Law, has vast criminal, civil, orphans court, and family law experience for 38 years. He loves family, law, and people, end quote. Karen Prendergast, quote, a York native and former Dallastown high school teacher, Kathleen has 21 years of courtroom experience. She combines toughness with compassion and can hit the ground running, end quote. Thomas J. Riley, quote, a career of service to my nation, state, and community has still instilled in me the drive to become a judge, to swiftly and competently and effectively help people, end quote. Neil Slanker. Neil Slanker draws on nearly 20 years of broad legal and experience in protecting people's rights, promoting individual accountability, and representing traditional York County values. Special thanks to HAC, York Campus, for hosting this public service event, to Constance M. Smith, Administrative Assistant, York Facilities Management Department, HAC Central Pennsylvania's Community College, for coordinating the logistics. How about a hand for our candidates? All right, these are the rules that have been worked out, which I'll try to enforce. We'll see how that all goes. We're going to open the forum. Each candidate will get a question. They will all answer that. They're limited then to 1 minute for the opening question. All the candidates, the first question. Then the panel has been divided into 2 groups. One group, the A group, and this was all done by draw. This is all random, the way they're seated up there, and the question order. So Group A has 3 candidates in it. Group B has 4. So I will ask some questions along with 3 panelists. They were all introduced to you, and they will pose questions to each group in alternating order with each candidate in the group, allowed 90 seconds to provide an answer. Then we will give each candidate, if they prefer, this is optional, 30 seconds to respond. You know, it's up to you as to whether you want to respond or not. Then I will conclude with a final question for each of the candidates. They will have 1 minute, and then we'll wrap it up. And following that, you're invited to, go to the back of the room and out in the hallway and hang out, as they say, on the college campus, hang out with the candidates and get to know them a little better, pick up literature. And I think it covers basically the rules. So here we go. My first question, and we'll start with over on the left side, my left, their right. All the candidates get this question. How many years have you practiced law? In what areas? And why do you think you are qualified to be a judge on the York County Court of Common Pleas? Go ahead.
Evening, everybody. Thank you for having us all here tonight. My name is Tom Riley. I've been practicing law since 2001, graduated from Dickinson School of Law. My career began some 25 years ago in corrections, worked my way up to as deputy warden. After that, I went into, I clerked for a judge, a common pleas judge, went into private practice, and then was hired by our DA's office here in York County, where I prosecuted everything from traffic citations to murder charges. Then I was fortunate enough to be elected magisterial district judge for the Spring Grove area. There I presided over everything from civil, landlord-tenant, summary violations, and of course, truancy and criminal cases. This expansive background that I have has given me the experience that I need and the judicial temperament that should be coupled with a qualified candidate to become judge to be one of the next judges at the York County Court of Common Pleas.
Thank you. Before we go next, they're going to be given a green card will show when they should start, yellow card with 15 seconds, and a red card with 5 seconds. I'm going to let them finish a sentence or two for obvious continuity reasons, and we'll be fair about it. Sorry, go ahead. Wanted to make sure everybody, and you understood.
Good evening, everybody. My name is Karen Comrie, and I've been practicing law since 2003. I began working in the criminal justice field in 1999, and my career spans over 20 years here in York County. I have worked as a caseworker for York Adams MHMR, as well as children and youth, an adult probation officer, and I had the opportunity to do my first jury trial before I passed the bar exam. I did a jury trial as a certified intern. So I feel that my extensive courtroom experience handling everything from murder cases to traffic offenses, as well as the fact that my entire career has been dedicated to public service, which includes continuing to represent individuals who can't afford an attorney in criminal or family law matters, that I can hit the ground running as a York County Court of Common Pleas judge.
Hi, I'm Chris Mangus. I've been practicing law since 1976. I was an assistant district attorney for 4.5 years. I did criminal jury trials, all kinds of criminal actions. I did criminal defense after I got out of the district attorney's office. I've tried civil cases in front of a jury, in front of a bench. I've tried all kinds of family law cases, and it is family law that I truly love. I want to be a family law judge. If I'm elected, I will ask to have the entire term be in family law. That is what I have grown to love. And I have also been a West Manchester Township supervisor for 6 years. And the cases that I've handled, particularly in the family law area in the last 20 years or so, I've been primarily family law for those 20 years or so. I've done in various counties. I've done York County, Lancaster County, quite a few cases, Cumberland County, Dauphin County, Adams County, and I think I've tried every kind of civil and criminal case there is. Thank you. Go ahead.
Good evening. I'm Neil Slenker. I am committed
to using the legal knowledge and experience that I've garnered in nearly 20 years of practicing law to do three things: to directly impact and improve people's lives in this community, to promote the concept of individual accountability, and to represent traditional York County values. In nearly 2 decades of practice at the firm of Stock and Leader, I have represented and protected the rights of individuals like you and me, businesses, school districts, municipalities, hospitals, physicians, police departments. That sort of well-rounded background is vitally important for a judge who makes decisions, life and death decisions, that impact people's lives in virtually every area of the law. I bring the right combination of experience, knowledge, and temperament.
Thank you. Go ahead.
Carl Anderson. I have over 30 years experience in practice of law, most of which as a trial attorney with a national law firm based in Cleveland, Ohio. When I graduated from Boston College Law School in '81, I was hired by the firm of Arter and Haddon in Cleveland, received excellent training, became within 8 years a partner with one of 150 partners in a 590 lawyer law firm. I've tried many civil litigation matters in a range of substantive areas, and tried to verdict civil jury trials across the country. Returned to York at the urging of Governor Rendell. My experience has been in the private sector, of course, as a private attorney, but also in the public sector. I served as chief counsel to former Governor of Ohio, Richard Celeste, for 2 years while I was a partner with the firm of Arter and Haddon. I came to Pennsylvania at the request of Governor Rendell to serve as chief counsel of the Department of Banking. I have a broad range of legal experience. Most of my litigation experience was,
No, finish your sentence. Go ahead. Finish your sentence.
is in the defense side, but for business clients, for individuals, I have handled DUIs, criminal matters, particularly for nieces and nephews of some of my clients. I've handled a range of things for individuals as well as businesses and nonprofit organizations.
Thank you.
Thank you.
Good evening, I'm Mike Flannelly, and I graduated from Wake Forest School of Law in 1982. I went into private practice for about 20 years, doing a wide range of civil litigation from the small cases up to very large and complex cases. In 2004, I was appointed as county solicitor, where I represent all the departments that make up the government, as well as the commissioners for their daily legal needs. President Judge Linebaugh approached me and asked me if I would consider an appointment to the bench after the tragic death of Judge Patterson. I was on the bench in 2013 and 2014, and I was on the family law bench, where I handled cases involving custody, juvenile delinquency, protection from abuse, as well as civil motions. So I believe that my background as a Court of Common Pleas judge, I'm the only candidate with that experience, will be helpful in me hitting the ground running. Thank you.
Kathleen.
Hi, I'm Kathleen Prendergast. I have been an attorney in York County for 21 years. Almost all my practice is in York County. I do, however, also have experience arguing cases in the Pennsylvania Supreme Court, the Pennsylvania Superior Court, and the Pennsylvania Commonwealth Court. Most of my practice has been in family law. I also, until recently, was one of only 11 custody mediators where we worked with both parents out of court to try to keep the cases out of court. I think mediation skills are also important for judges. I think that judges need to listen carefully, respect everyone in the courtroom, know the law, and apply the law. My practice has been in the courtroom. I also have been in orphans court, and I have done a limited amount of practice with juvenile cases in criminal court. I think that all of that practice will help me to really come in and hit the ground running. I think that's common expression. And because we've been short on judges, that makes that particularly important.
Thank you. All right, now just as a reminder, the first question will come from John Euler, and it will go to Tom, and then Karen and Chris will answer the question. And then we'll do the rebuttal for a few seconds if necessary. Judge, go ahead.
Very well. No judicial candidate nor judge-elect nor judge has a right to stake a claim to a particular division. Please discuss, Tom, your goals and cases involving delinquent youth, and what could be done to best assure positive direction for youth in the judicial system.
Right now, as a sitting district judge, part of the matters that I hear that come before me involve truancy issues along with summary violations where juveniles are involved. I believe that you need to have a good approach with respect to sentencing. You need to have a wide battery of information there that will allow you to make certain that whatever sentence is doled out to that particular individual, it is a correct one. To make certain that this individual stays on the correct path and is redirected to where they actually need to go. I've had some success in this area. I've had many juveniles come through where I'll have them come before me, set a fine high enough so that they'll elect to take a hearing, and then they'll show up in my office where I'll be able to have a discussion with them and ferret out what is really going on here. And that's really key. Trying to determine what is at the root of the problem, whether it be the family, whether it be something in the child's schooling, what have you. It's necessary as a judge to be able to discover what is motivating this person to commit these particular offenses, and then be able to devise the appropriate remedy to make certain that it doesn't happen again. I'm out of time, so thank you.
Okay. Go ahead.
Same question.
Same question.
Okay, with my experience when I worked in the district attorney's office, I supervised the juvenile units that handle juvenile delinquency cases, and I actively now represent juveniles. I can tell you what the root of the problem is in most of the cases. It's a lack of family support. Most of these kids that come in, there is an absent father and a single mother that is struggling with not only that child but other children. So what needs to be looked at is what we need to get to these kids earlier with the school system and also community resources. Meeting with members of the community to see what the needs are in every school district. Each school district is different and has their own individual concerns. I can tell you also as a parent, my daughter was not the easiest individual to raise, and we actually went through some issues with potential truancy, and I had to drive her to school every day to make sure she walked in the door. My parents helped out with that, so we need to look at what is going on with these families and offer services earlier before they get involved with the juvenile system. Once some of these kids are in the system, they think it's a joke. Some of the punishments need to be a little more harsh, but the ones that need a break, and I've even talked to some of the kids, and I'm very straight and direct with them. Some of the attorneys can take that initiative too. You never know what child is who they're going to actually listen to, and something you may tell that child may stick in their head.
Thank you. Chris?
Relative to juveniles, frankly, I think Karen said it very well. Allow me to just add that my experience in child custody, child delinquency, and child dependency, I think, makes me uniquely qualified to be able to analyze the needs of the family. I think Karen's absolutely right. A lot of it is lack of family support. And I think a judge needs to make sure that, for example, in dependency court, that a foster care or an institution is the absolute last resort for these children. I would like to see more emphasis on kinship care, where grandparents, aunts, uncles, cousins, godparents, whomever the child or children know and feel confident with and feel loved with, that those resources could just make a tremendous difference in each and every child's life. I think it's important we look at every child and every family individually, not just rubber stamp and sort of cookie cutter these things. Every family is unique, every child is unique. We need to spend the time in early intervention. Again, as Karen said, we need to spend the time to find out what is uniquely best for this particular child or children, particularly relative to how they're going to be raised, by whom are they going to be raised, and it should not be the government, it should be family.
Thank you. Now, any of you want to respond? Tom, Karen, Chris, you get 30 seconds if you want to use it. Anybody? You're okay? Okay. Then we'll go to Scott Fisher. His first question goes to Neil.
Do you believe the composition of juries adequately and fairly reflects society at large? What are the pros and cons of using driver's license, registration, tax, Department of Public Welfare, and voter registration rolls or lists as a source of jurors? That question almost took a minute and a half. A couple of good points there. One, in terms of the pros and cons of using the driver's license renewal for voter registration, I think that is an effective tool to getting people who are otherwise not registered to become registered. The downside is, of course, if we rely solely on something like that, then that leaves out a large portion of the population that doesn't drive, doesn't have to have their license renewed. I think the more fundamental point, though, probably goes to the issue of whether or not our juries reflect a cross-section of our community. And the answer is sometimes. And part of the issue is if you look at typical jury composition, you'll see that it's often made up of retired folks and that people my age, working professionals, will do what they can to avoid serving on jury duty. That's a real problem. And one of the ways we have to deal with that is to be stricter in terms of administering what sort of excuses we'll accept when people seek to get out of jury duty. I know physicians who have told me they do whatever they can to get out of jury duty so they can maintain their practice, but those are the same people who then complain to me that jury verdicts in medical malpractice cases are too high. So my response to them, and all of them, is before you can complain, you got to be willing to sit on a jury and cast your vote in terms of a civil case, what an award would be, or in a criminal case as to guilt or innocence.
Carl?
Could you repeat the question again?
Do you believe the composition of juries adequately and fairly reflects society at large? What are the pros and cons of using driver's license registration, tax, Department of Public Welfare, and voter registration rolls or lists as a source of jurors?
Yes, I do think that jury pools generally do not reflect the demographics of the society at large, and in York County in particular, that tends to be the case. The means by which jurors are selected, you mentioned the lists that are used, the voter registration, driver's license, welfare rolls, and what have you, are appropriate, certainly to identify prospective jurors. What happens, though, is that you still fail to capture a lot of individuals that would otherwise serve on jurors. More importantly, though, the process of jury selection in the actual administering of justice, that is, the jury selection process in the courtroom at times, tends to reflect a certain bias. And oftentimes, even when the jury pool reflects demographically the population, meaning minorities and others, there's a tendency at times for prosecutors and others to utilize their preemptory challenges and others to exclude these folks from the jurors. Many times it's because of inherent bias, other times it's because they believe that particular person, because of that bias, may not be sensitive to the positions that they're taking in the case, or that they might be more sensitive when it comes to one who's a victim in certain types of matters. So it's a complicated issue. I think efforts are made, obviously, to include representatives of the community in the jury pools, but I think the process by which jurors are selected reflects a certain inherent bias that we obviously have to try to strive to overcome. And having more underrepresented parties in the jury pool and finding a way to do it is important.
Okay, thank you. Mike?
I don't know that I have a great deal to add to what Neil and Carl would say. I would note, first of all, and I'm not just saying this because our current court administrator is in the room, but I think when I first started practicing in York, time's up already? When I first started practicing in York, you could go up to the court administrator and prevail upon him to get your friend off of jury duty. That is no longer the case, and I think that has done a great deal in making it so that people know up front that it's not going to happen. You're going to have to go on jury duty. I think the problem that Carl alluded to is a more serious one, which is our system of strikes that are given to attorneys are going to perhaps strike people off a jury that might represent a particular ethnic background because the attorneys perceive that it's in their benefit to do so. And there's really nothing that can be done from a court administration standpoint to take care of that issue. That is going to have to be a more systemic change. Ultimately, the litigant's faith in the jury is critical. If you don't believe coming into that courtroom that jury is selected from your peers, you're not going to have faith in the ultimate result. And I believe that we are doing as much as we can to get the broadest possible jurors in the courthouse, but as we discussed earlier, there are systemic problems which prohibit that.
Thank you. Kathleen?
Problem with going last is that everyone has already made the good statements by the time you get here. I think the more methods that we use to create the jury pool, the more we're going to draw from the population at large. I think we're starting to see problems around the country when you have not just bias, but even the appearance of bias. And if you have a disproportionate number of criminal defendants who are African American or Hispanic with a jury pool that's all white, it does not give the appearance that it is a just system. And so that's why I think the more methods that you use to pool and create a jury pool that's reflective of the population at large, then you can see a larger appearance of justice within the system. Because I think that we all have an effort, we all have a responsibility to be sure that there is not systemic bias, as opposed to, we can't prevent certain individuals from being biased, but we need to be all on guard that we're not creating systemic bias. And that's where the jury pool question becomes important.
Okay, any of you want to respond? You have 30 seconds if you want to use it. Anybody? You're not allowed to under the rules. Sorry, I get it. But actually, you get the next question. David, go ahead. For Karen.
Question 4 will be for Karen, then Chris, then Tom.
Right.
In the area of hate crimes, what are some of the issues in balancing free speech rights against the need to control offensive activity?
Wow. Well, obviously, under the First Amendment, we do have freedom of speech, and there is an issue with when does that, can you hear?
Yeah, maybe if you hold it up a little bit closer.
I think it was off.
Oh, okay.
Yeah.
Okay.
Anyway, as I was saying, we have a constitutional right to free speech under the First Amendment. However, where do you draw that line with hate crimes and hate speech? There was one of the sitting judges now actually handled a case which he had the gumption to take to the U.S. Supreme Court, which I believe most of us as practicing attorneys knew that was going to be a losing case with the church that had protested at the funeral. But when a case comes in front of you, you have to look at what the First Amendment right is versus what the behavior is. And obviously, the hate crimes are not going to be tolerated. As a common pleas judge, a lot of that I don't believe is going to come before you. There are cases involving ethnic intimidation in the criminal arena, which obviously would be in the York County Court of Common Pleas.
Chris, yes.
Once again, I find myself agreeing with Karen. That is primarily, I think, a federal court issue, and I'm not sure how much that would get in front of a York County jurist. But I would just say that I think, much like the case you referred to, when in doubt, I think freedom of speech and freedom of religion perhaps should come out ahead. I remember studying in law school a case where the ACLU defended the Ku Klux Klan when they wanted to have a parade, and the city of Chicago prohibited that. And it was decided that as offensive as the Ku Klux Klan would be to virtually everybody, they had a right to have a parade like anyone else. So I think when it's all said and done, the freedom of speech and the freedom of religion have to be foremost. Those are the very things this country was founded on. And unfortunately, some of the cases in the television, radio, and on the internet now have to do as much with freedom of religion as they have to do with freedom of speech. But I think those two, when at the end of the day, I think those two have to prevail.
Okay, Tom?
Well, in this matter, clearly, the Constitution is going to be the guide. Hate crime, however, is never acceptable under any circumstance, and I don't think there is anybody in here who would disagree with that. At the same time, I think we would all agree that speech must be protected, no matter how offensive it may be, no matter how deplorable it may be at times. The Constitution in our country gives us the right to say mean things to folks at times when it's very deplorable and offensive as it may be, but it's that right that we're guaranteed under our Constitution that applies to all, no matter what you want to say. And I think it's very important that we don't lose sight of that. That said, I can tell you that there have been times in my courtroom where there have been instances, generally among juveniles, where the offense has been racially motivated. And I can tell you as well that the penalty that I set in those cases when they were ultimately found guilty was high to make certain that a message is sent that people understand that this is not the sort of thing that will be tolerated within our community. And I don't think there's anybody here who would disagree with that either. That is not the sort of example we need to set as people, and that's not the sort of example we want to set for our children. And accordingly, it will be treated harshly within my jurisdiction.
Anybody? Comment? 30 seconds? Follow-ups? Anybody? Okay, I asked the next question, and it goes to you, Carl, and then we'll come down here and end up with Neil. As you know, there have been some controversies in the state over the secrecy of grand juries, and obviously in county courts you have, court-sealed files and closed court proceedings that go on. Under what circumstances do you think the court should seal court files or close court proceedings?
Well, first of all, the rules are such that these are secret proceedings,
Right.
and quite frankly, nothing that goes on before the grand jury should be disclosed, period. And as a lawyer, obviously, and as a judge, I would recognize and respect those rules as they exist. And it's not a matter of what's in the public interest, but it's already been determined by the legislature and the rules as promulgated by the Supreme Court that these proceedings be conducted in that fashion. All towards the administration of justice, all towards trying to reach a just decision under the circumstances. I don't know at this point that as a judicial candidate it would be appropriate for me to speak to anything that might come before me or what my predisposition might be with regard to those rules, other than to simply say I would administer the rules as they exist. And right now they would not allow for disclosure of the information that is presented to a grand jury.
Mm-hmm. How about the court files and closed court proceedings that might come up in the local court? If I can just follow up
that's
quickly.
up to the judge to decide.
Okay.
That's up to the judge to decide whether or not that's appropriate under the circumstances, and I leave that's at the discretion of the judge. And I, frankly, would not want to hamstring the judge with regard to when it's appropriate to seal records or when it's appropriate to admonish those involved in the proceedings not to discuss a matter, although it's a public forum.
Right.
There are circumstances where I think that's appropriate.
Okay, Mike. That's the timer, I think. Go ahead, Mike. Sorry.
Yeah.
We get 90 seconds. You get your time now.
That's all right. I'm pretty sure I won't need the entire 90 on this one. I agree with Carl that obviously if the statute requires secrecy, then that must be applied. Obviously, in our Attorney General situation right now, that's currently an issue showing that nobody's above that particular law. I think the more important part of the question deals with when is it appropriate to seal files. As a general rule, I'm against sealing files, but I do recognize there are certain circumstances in which it's appropriate. So one of my jobs as county solicitor is to deal with guardianship proceedings. And there are circumstances under which it may be appropriate to seal certain parts of those records when it deals with health information or mental health information as to an individual. Obviously, juvenile situations are those are protected by statute. There are cases involving where witnesses may be testifying, which, if information was to get out, that would potentially result in harm to that witness. Those are the kind of very limited circumstances in which I would be favoring sealing the file, but generally speaking, I would be against that.
Okay, thanks. Kathleen, court files, closed court proceedings.
At this level, we don't really get to create the law, we just have to apply the law. And I think the simple answer is that you seal the records when the law either requires it or permits it. Then, you know, it may be a gray area. Where it requires it, obviously you do. For instance, all juvenile matters are sealed. Mental health records are sealed. If there's a danger to one of the witnesses, then that's permissible. If there's a possibility that the defendant may not get a fair trial, there may be some preliminary matters that may need to be sealed. So really you just try to figure out if you're presented with an issue where the attorneys present a case for the law to seal the record, that's when you do it.
Neil.
In order to have faith in our system, our justice system, it's important that the public be afforded the right of transparency, because otherwise it creates the presumption, or at least the perception, that things are going on behind closed doors. So I think as a general rule, transparency is what's required. Now, with that said, as been noted, there are circumstances where the law requires things to be sealed, obviously juvenile situations, mental health situations. In terms of the grand jury, many times in Pennsylvania, the grand jury purpose is investigative, as opposed to an indicting grand jury, which you see on television a lot in New York and things like that. And you know, keeping those proceedings confidential is important, because it's not a trial of guilt or innocence. It's an investigation, very similar to an investigation that law enforcement authorities may undertake. And harm can be done if those things are disclosed. It can result in people being convicted in the court of public opinion. Those are things best kept confidential. And then if a decision is made to bring charges, that of course is handled in the public forum in an open trial setting.
Yep. Anybody want to comment? You all get a few seconds. Okay, Scott Fisher has the next question. Goes to Chris. That would be the third individual in.
Chris, then Tom, then Karen?
Yep, that's right.
Okay. What qualities have you seen in a judge that you would like to emulate? And conversely, what qualities have you seen in a judge that you would not like to emulate?
No such luck. No.
The qualities that I think should be emulated that I have seen would be patience, thoroughness, conscientiousness, the wanting to get at the bottom of the issue, wanting to get to the truth, wanting to do what is just, wanting to do what's in the best interest of the litigants, what I do, what is in the best interest of the children. I've seen many judges in York County and in other counties do this and do this very well. Some of the qualities that I think should be avoided are, quite frankly, anything that resembles temper or anger. I think all litigants and all attorneys should always be treated with respect. If I'm elected judge, I will treat the people in front of me exactly as I would want to be treated if the tables were turned. And I think that kind of civility by judges is incredibly important, because it speaks to people about our justice system. Is our justice system unbridled power that can result in anger, or is our justice system truly justice and getting to what is best for the people involved, what is true, what is just, and what is civil? And I think judges have to set the example in that regard.
Well, one of the things that I've noticed over the years is that the practice of law is difficult enough. It doesn't need to be made that much harder by the person on the bench. accordingly, I try to make myself as invisible as possible. You shouldn't have to even speak up or say anything and until it becomes necessary. And so I want to make certain that what goes on in my courtroom is done civilly and done directed toward me rather than the opposing party. I want to make certain that the decisions are doled out in a swift, competent, and effective manner. Swift justice must be done. Justice delayed is justice denied. And so if the decision isn't made within a timely manner, within days rather than weeks or months, then it's really of no value the further out the road you get. Competently. A judge also needs to know the law and know it well for that particular point and apply it, marry it up effectively with the facts that have been presented to him. And effective. The decision must be an effective one as well. If it doesn't suit what's being brought before you and it doesn't resolve the issues that have been presented, then it's of no value to the parties involved. And so swift, competent, effective decision-making in a timely manner is what's needed. And lastly, for the attorneys out there, be on time. You know, the judge needs to be on time and on the bench at the appointed hour.
Karen.
In my years of practicing in York County as both an attorney and before that, I have appeared in front of every current sitting judge that is on the bench now, the senior judges, all of the MDJs, most of the senior MDJs, and I can tell you that as far as what I would consider to emulate, I have a story. When I was first a prosecutor in a courtroom and handling a probation violation, I was in front of a judge and the courtroom was quiet as I was standing there reading the report, and you know, you get that feeling when everyone's staring at you, and I looked up at the judge and I said, "Hi." And he was very patient and understood I was nervous. So, and that taught me something. He didn't yell, he didn't belittle me, he worked with me. And some of the other judges I have been in front of, they have trained me and they mentored me. When I was promoted rather quickly in the district attorney's office, and I was petrified because I did not know what I was doing. So I was placed in front of Judge Blackwell, who was known as the training judge. And she was very patient with me. And she explained when I would make mistakes. She would give me praise when I did things correctly. She was one of the hardest working judges I have ever seen, and I hope that I can be that way if I am elected judge. As far as things not to do, I've been in front of judges who belittle everyone. They will go right down the line, and I'm not sure if that is something with them, but I would not do that to anybody.
Thank you. Comments, anybody? You have additional 30 seconds if you want to use it. Okay, then we have David. Question for Mike. We're working our way down here in the B group. Go ahead.
So it'll be Mike, Kathleen, Neil, and then Carl.
Correct.
Judicial candidates are not supposed to say how they would rule on particular cases or issues, but they are allowed to express their views broadly on some socio-political issues. Can you give us a general characterization of your socio-political views?
90 seconds. The answer is no. You might want me to expound on that. I think from a general standpoint, I would argue that, or state that, generally speaking, I think that fairness in society is a fundamental view that I hold on to. I would say fairness and respect. Those are two things that we need to cling to in these ever-changing times. As you can turn on the television station and look at Baltimore, you can see how when people don't have that basic faith that society is just, you get one side of that, and you also get the side where there is lawlessness. And so, getting back to my point, wherever that was, I would say that from a general standpoint, I would argue that fairness is one of my fundamental beliefs. I believe that that respect is also a fundamental belief of mine. And that's something I carried into the courtroom, whether as a litigant or as a judge. And I think I was able to emulate that to the, I'm getting my wife's telling me I'm not talking into the microphone. But I would just simply say that that is a core belief of mine.
Kathleen's next.
Well, I will say, too, I don't know if when they went over with the rules, we are not allowed to give our party affiliation. So I think your question might run contrary to some extent to that direction that we were given. I think that, generally speaking, judges are the ultimate defenders of the Constitution. We take an oath to protect and defend the Constitution. I think that's what we have to do. From a social standpoint, I think as a society we need to be sure that our focus is on children and families. It's not a surprise that someone who took the time to get 2 education degrees, taught school, and spent 21 years in court representing children would think that we need to focus on children in our society. That should not be a shock to anyone. I think that that is reflected in what I've done and not just what I've said, and I'd like to continue that as a judge. Maybe that will give you where I'm coming from.
Neil?
To understand what I believe and what I think, it comes down to really 2 points. One is the idea of fundamental fairness. The other is the idea of individual accountability. And what I mean by that is the idea that I believe everyone should be responsible and take responsibility for the things that they say and the things that they do. That's something that my parents drilled into me. It's something I teach my children. And if you think about it, it's something that's sorely lacking in our society today. And what a better place we would live in if everyone embraced that value. In terms of whether you characterize someone as social or conservative or where they are on hot button issues, you know, you study the rules of judicial conduct and you see that, you know, there are some standards as to what you can and can't say and things that you can. And I agree that I could give you my personal opinion on various hot button issues as long as I clarified under the rules that that doesn't impact how I would rule on the bench. But one of the things that I decided when I decided to run for judge is that it would be reckless of me to start saying what I think on hot button issues, because it creates the perception in someone's mind that if they're before me on that issue, they don't get a fair and unbiased hearing. And that's wrong. And I decided if I'm going to be held to that standard as a judge, that I'm held to that standard as a candidate starting right now.
Carl?
Thank you. I view judges, particularly judges in the Court of Common Pleas, that have the responsibility to provide a fair and impartial forum for the disposition of matters before them. So the issues of fairness and impartiality are important to me. As I look at the Court of Common Pleas in York County, as a Yorker, a third-generation Yorker, having grown up in York and graduated from William Penn in '71, I know what it is to be a Yorker. I know what the court means, particularly for my community, the African-American community. As I've returned to York, I've been here over 10 years, almost 15 years now, I look at that system, and I think it's important for the citizens that the court be viewed as an institution where fairness and impartiality is upheld. That's the duty and responsibility of the judges, but the process by which the administration of justice on the civil and criminal side takes place is one that the citizens view, and when you look at the view of the minority and disadvantaged community in York County, there's the perception of inequality and a lack of fairness. And for many people, that perception is reality. I looked at the numbers and look at the statistics. I see that there's a disproportionate number of disadvantaged minority young people that don't have the opportunity to go through the art program and other remedial programs that might give them a second chance. I see that there's a disproportionate impact on those who end up with a felony record, which in effect ruins their lives. I'm not saying that the system is corrupt and it's not unfair. I just think that fairness warrants that we have judges that uphold their duty of fairness and impartiality.
Thank you. Anybody want to use an additional 30 seconds? You're saving us a lot of time, I will say that, about anything else. All right. Yeah, I have the next question, and we go back to Group A. I think we've recycled now to Tom. I think as you know, there are a number of circumstances under which judges would recuse themselves from cases. I mean, one might be political connections and relationships, because we, after all, have elections in this state for judges at all. Every single judge is elected, state as well as, the county. So broadly just talk about under what circumstances you would consider recusals important.
When I am unable to fairly and impartially decide the case.
Yeah.
That's the standard. If a judge is unable to do that for whatever reason, that judge must recuse himself. It's happened to me before. I've recused myself in certain circumstances where I was, in my opinion, a little bit too close to one of the parties in the case. I asked to be recused. It's not a big deal. If it's going to impact the case adversely, and if it's going to cast the bench in a bad light, because the perception in the community will be such, well, obviously that judge knew somebody, so that's why they ruled that way. Well, you can't have that. If the judiciary is tarnished, the community is tarnished as well. The community must have ultimate respect for the bench. It is ultimately important that is done. It is ultimately important that the judges on the bench do not feel that it be inappropriate to recuse. If you cannot fairly and adequately decide a case, recuse yourself. It's as simple as that.
Mm-hmm. Karen?
I would reiterate what Tom just said, and I would also add that if it appears that you cannot decide the case fairly and impartially, then the judge should recuse himself or herself. Also, attorneys can file motions to have the judge recused for whatever reason, and then the judge has a hearing on that motion. And if that would happen, then obviously I would take a look at what the facts were presented, and if I felt I could not fairly and impartially hear the case, then I would recuse myself. Being from York County and growing up here, I know a lot of people. I've seen a lot of people come into the court system, and I have done that mostly in the district attorney's office. If I felt I could not prosecute a case because of a friendship or family relation, then I would not handle the case.
Chris?
In addition to what has already been said, I would recuse myself for a period of time at least to have any of the attorneys that are currently in my firm be in front of me. I would probably recuse myself forever of having my son be in front of me as an attorney. I would recuse myself for my campaign team, close members of the family. And again, as was said or implied by both of my predecessors here, I think it's important that there be not even the appearance of any impropriety. Judge Schneider will not let me try cases in front of him. I was scheduled to try one in 6 months or whatever ago, and he bumped it to another judge, even though he and I have not been in the same law firm for 18 years. While that slightly surprised me, it pleased me that he erred on the side of there being not even the appearance of impropriety. So it's not just whether or not I could try the case impartially without even a shred of bias or prejudice, but also how does it look? And I think it's just incredibly important there not be even the slightest appearance of any kind of favoritism or bias or impropriety.
Follow up, anyone? Hearing none, we'll go to Judge.
Kathleen, now you're first.
Yep.
If you become aware of unethical conduct on the part of an attorney or a judge, how would you handle it? And do you believe judges should be required to report attorney misconduct to the disciplinary board?
There are times under the disciplinary code where reporting misconduct is mandatory. It's not really optional for us, either as attorneys or judges. And in those cases where, there are some cases where I think there's conduct that is in the gray area. And if it's in the gray area, I typically try to address it with the attorney first, so as not to prejudice my client, the case, or justice. In If it is not in the gray area, if it's a very clear case of ethical misconduct, then it's not really a question. We must report. And I think that's something I know some attorneys have not done, but we've had some very good examples here in York County where it's been difficult, but they have reported, and attorneys have been disciplined accordingly. So I think that's very important for us to police our profession.
Yo, you're next.
Well, both the Judicial Code and the Code of Professional Responsibility applicable to attorneys require the reporting in certain circumstances, and it is what it is. If you encounter that sort of circumstance, you have to report. What Kathleen mentioned about the gray area tends to be where things fall in our society in just about everything. Rarely are things so clear-cut that we can say it's one thing or another. And it's often in how we handle those gray areas where maybe not all the facts are clear or we don't know all the circumstances, that we have to be very careful about how we proceed. And is that a matter of speaking directly to the person first to ascertain the facts, or going directly to the disciplinary board? Now, one thing that's worth noting there is that just because something is lodged with the disciplinary board does not mean that it's an automatic determination of guilt. The disciplinary board does, in fact, have a very effective investigative procedure where they afford due process and things of that sort to allow someone to explain their actions, because, as we said, quite possibly we don't know all of the facts and circumstances, and that's frankly one important quality of a judge, that he doesn't rush to judgment, that he thinks about, investigates, and understands what we call the totality of the circumstances.
Okay. Carl?
Well, I don't know that there's much I can add to the comments that have already been made, Judge Euler, but, I tend to agree that, if it's clear, you have a affirmative obligation to report. There are the gray areas. My preference, of course, in the gray areas is to approach it, as Kathleen mentioned at times, to mention it to counsel. Obviously, though, if it's something that's going to affect my ability to represent zealously the interests of a client, then that's a little different, and I'm going to obviously report any unethical conduct at that point. That's about all I could add. Mike?
Yeah, I would agree with Carl. There's not a tremendous amount to add on this particular subject. As far as, obviously there are circumstances which require mandatory reporting. The situations which come up, which I think are, which come up in the gray area, are when you see an attorney who is not adequately representing a client to the point where that client's case is in danger because of the poor representation. There's a scenario which you could have the ability to report that to the disciplinary board. I perhaps would take the tack that, first of all, that the litigant shouldn't be punished for poor representation. But secondly, if that lawyer was a part of a firm and there was a more senior partner, I might go to that partner and address that directly with them to see if this attorney could use more training and more mentoring before being allowed to appear in court on their own. The one thing that I don't think can ever be tolerated is honesty to the court. And I know, for example, Judge Euler is not somebody who tolerates not only dishonesty but fudging. And lawyers are kind of famous for fudging. So, I've always made it a point in my conduct with the court to always be forthright and honest. I think that has helped me through my career, and I certainly would hope that the lawyers that would appear in front of me if I was elected do the same.
Okay. Comments, anybody? Nope. All right, we're back to Group A with David. A question. First question goes to Karen, and to Chris, and then to Tom.
Do you believe that all citizens have adequate access to legal help in the legal system? If not, what can be done to provide wider and better access?
I certainly do not believe that all citizens have access to the legal system and representation. And what can be done, I know what I do. I take at least one client a year and represent them pro bono, whether it's a criminal case or a family case. Currently, I'm helping a woman I represent in dependency file child custody paperwork. As far as what can be done, your county seems to be lagging a bit behind the other counties in the state. Adams County has a self-help center that was started several years ago, and I use that as an example. York County does have a self-help center finally. However, the woman I was just referring to, she brought in a packet of forms she was given for custody and basically told, here are your forms, good luck. So as an attorney, I found it extremely difficult to go through that stack of paperwork and figure out what she was supposed to file and what she was supposed to do. So I think that is an area that can definitely be expanded in this county as far as the actual forms that are contained online and as well as the help that is obtained. And one thing that can be done, attorneys can volunteer with the self-help center or be placed on a list so that the people that go in as pro se litigants can go to an attorney for a reduced fee to help them, as Mid-Penn Legal Services only takes so many cases a year, but it is certainly a problem.
I tend to agree in principle with what Karen just said. I would say, and I think she may have implied this, self-help centers I think are a little overrated. I think it's important for litigants to have legal representation. Both myself and my firm have received many pro bono awards each year in front of the Bar Association dinner. I've done a tremendous amount of pro bono work. My firm has done a lot of pro bono work. I think every attorney and every firm should volunteer to do pro bono work. I always do far more. There's supposed to be a minimum or an opt-out. I've always done far more than the minimum, going to the divorce workshops, going to the custody workshops. I have represented many pro bono people in the family law area, in custody and divorce and other areas, and I've always done so at least as fervently as I would if I were being paid. I think it's very important that we attorneys really buy into pro bono help and to really helping those who cannot afford to pay for legal services. And I think we need to also do everything we can to support Mid-Penn Legal Services. I think I've done that. I know our Bar Foundation has done that. They do an excellent job there, but they need help from the attorneys. Tom?
Well, I think the York County Bar does an exceptional job with respect to pro bono work, and I think they should be commended for that. In addition to that, I also believe firmly that our public defender's office here in York County is unparalleled. I've had the pleasure of working with the public defender's office through my years down at the district attorney's office as a prosecutor, and I can say to you all that there is filled with many fine attorneys in there, all representing their clients zealously. I can tell you from my perspective as a district judge that my bench is stacked with mounds and mounds of pieces of paper to refer people to the appropriate resources so that they can actually get the representation that they're looking for. Whenever I arraign a particular defendant in a criminal case, I make certain that that defendant has all the information necessary so that they can make application to the public defender's office for representation. I make certain that before that person leaves my presence, or a lot of times we do it on video, I make certain that they are fully aware of how to go about to make application to the public defender's office so that the next time they do appear in court, they are represented and represented quite well.
Further comments? Oh, go ahead.
The only thing I'm going to say is that most attorneys are in business to make money. And I have told several clients that have come in to me, especially for support matters, to save their money. When I went through the support court myself, I talked to an attorney and he said, there's nothing I can do for you that you can't do yourself in a support hearing.
Thank you. Go ahead.
I would like to add also, I think Tom's absolutely right. The Public Defender's Office in York County does an incredibly good job. They have conscientious attorneys, and I just would second that.
Okay, I have a question. We're back to Neil, and then we just cycle through the panel. And my question has to do with individuals who want to represent themselves, obviously without appropriate, quote, legal qualifications, end quote. how would you deal with that if they end up, coming before your court?
Well, this is a sensitive issue for attorneys because for a number of reasons. Obviously, individuals have the right to represent themselves in court. Now, there are some exceptions to that. For example, if you have a business that's a corporation can't represent itself in the trial court. And I think it's important that people have that right. They have the right to appear in court and defend the claims against them or to assert their claims. The challenge, though, is that our system, when it operates efficiently and effectively, is based on rules and procedures. We have a lot of variables that we have to account for, and you need to know those rules and procedures, like the rules of civil or criminal procedure, the rules of evidence, things like that, so that it works effectively. Pro se parties, 99% of the time, aren't versed on those issues. So a judge is in a very difficult position, and I never envy a judge who has to deal with this where one party is pro se, because he or she needs to protect that individual's rights, and often that means giving them a pass on violations of maybe a rule of procedure or a rule of evidence, typically the more administrative procedures. But it makes things very difficult, and that then causes an impact on the other party who says, why is this person getting additional latitude? So I welcome, in lieu of pro se representation, the resources like at the Self-Help Center, pro bono work, and things of that sort to find a way to get individuals who cannot afford counsel the professional representation that they need so that the system works effectively and efficiently.
Okay, thank you. Carl?
Yes, there are challenges where there are pro se litigants. However, York County is an area where we have a high concentration of poverty. And where you have a high concentration of poverty, you're going to have people who are just not going to be able to afford counsel. Even through and I do commend the York County Bar Association as a member for what it does. And the pro bono program is exceptional, and the law referral process program is effective. However, you've got substantial numbers of York Countyans who can't even afford the $50 they may have to spend to have access to the law referral service. So, yes, it's a complicated issue. We don't have the resources to provide counsel for everyone. That's a problem throughout the country. Certainly a problem here in York County. What that means, though, is that I don't necessarily think that a person who is pro se should be punished because they don't understand the rules of procedure and evidence that we lawyers are trained to understand and appreciate. I think some deference should be given to a litigant who's pro se. I think the judge has a responsibility, not so much in the sense of giving an edge or a disadvantage to the other litigant. I think in the quest for fairness and impartiality in that proceeding, he must assist a pro se litigant in the proceedings before him, because that's important if the integrity of the court is going to be maintained. Because that litigant starts out from square one at a disadvantage when he's up against a skilled lawyer like Neil Slenker on the other side. So I say to you, I think the judge should give deference, and let's face it, there are problems with the self-help programs, but anyway, that's my position. Thank you.
Mike?
I unfortunately have a unique perspective on this problem because one of my duties as county solicitor is that all the people who want to file for the right to proceed in court without having to pay their court costs first have to come through me. So the bottom line is, every day on my desk I will get a folder from the Prothonotari's office containing anywhere from 2 to 11 of these cases. And the vast majority of these cases are custody matters. There's occasionally the odd appeal of a driver's license suspension or a landlord-tenant, but the vast majority are for custody cases, and in these cases, both of the parties are unrepresented. So we don't have the scenario, the typical scenario isn't one party represented and the other party is not. It's both parties are unrepresented. And when I was on the family law bench, this happened quite frequently where you would have both parties self-represented. And the question is, do you apply the rules strictly, or do you look out for what's in the best interest of the kids? And obviously that's not a tough decision to make. So does that mean sometimes you as the judge have to ask questions to draw out testimony which is necessary for the court to render a decision? Absolutely. But it is going to be a problem that's going to be facing the York County Court of Common Pleas from now into the considerable time into the future, given what's coming across my desk every day.
Kathleen?
One thing that's different between some of the courts, different areas of the court, specifically criminal court and family court, is that in family court, the judge has, by law, an independent responsibility to develop the record. And there was a case where one of our judges was reversed because he didn't order a home study in a case where neither parent had requested one. The Superior Court felt that he should have done that despite what the parties had requested. So you do have an independent responsibility to develop the record. In family court, we have pro se parties all the time. I have had pro se litigants as a mediator, where you have them and they reach an agreement, but then there's no attorney to write it up, and then they have to go into the judge who tries to, put it on the record. Karen had indicated that Judge Blackwell is a very good mentor for new attorneys, and I think sometimes the approach you take for pro se litigants is similar to the approach you take for new attorneys who may be learning what they need to do. There also is a difference between procedure and law. I think you have to be very careful about what you do with regard to law, but you can require and give information with regard to the procedures that you expect to be followed in your courtroom in a way that is not frightening to them because they're there to deal with an important issue. You have to be respectful, but you also need to let them know in a friendly way, this is kind of where you need to go.
Anybody? Follow up? Anybody on that one? All right, go back to the judge who has a question. We're back to Group A with Chris.
Chris, while serving on the bench, do you believe you have a role in bringing important legal or judicial issues for the public or the legislature? Why or why not? And what should your role be?
I'm not sure
Is it on?
I'm not sure I followed that just now. I don't see how there can be a role to bring things to the legislature because by that very nature, if you're bringing a problem to a legislator and you are a judge, a legislator is going to ask, well, what do you think should be done? And I think the minute the legislator asks that question, any answer you give is going to be violative of the judicial code that the judges may not take stands on issues. They may not in any way support political candidates or support specific bills in the legislature. I mean, that's just verboten. And in terms of bringing issues to the public, I would have to give that more thought, but I tend to err on the side, again, that judges have to be and have to appear to be totally objective, neutral, and so forth. I think the minute a judge brings to the public an issue, it starts to sound political, and I would be very uncomfortable with that. Now, again, I think that might be issue by issue. I'm not stating that as a certainty, but again, I would want to always err on the side of being totally impartial and totally apolitical in anything of public nature.
Question now goes to Tom.
I think with respect to bringing to the attention a matter or an issue that appears in your court and for redress, I don't think presents an issue. How else is a legislator going to find out what doesn't come from the bench? And I think the bench has one of the strongest voices when it does come to the legislature. And so when it comes to an issue that appears before you time and time again, I don't think it would be inappropriate to bring it to the attention of the legislature. For instance, we can all see in like domestic violence cases where they're treated as a summary offense. One of the issues that could be raised is to make that occur like a retail theft. Count each offense, and it builds up in gradation. So if it would start as a summary, the next offense would count as a misdemeanor, and so on down the line. That would be something that the legislature would legislate. That's not something that a judge does from the bench, but I don't think it creates an issue to bring it to the attention of the legislature. So where there is an issue in how the court operates or how Laws are written. I don't think there's an issue with that. I think that it's appropriate for a judge to do that.
As far as the first part of the question goes, I do not feel that it would be my role to bring important issues to the public. Rather, it would be my role to take them to the president judge and the other colleagues on the bench, and then the president judge would be the one to go to the media or release those issues to the public. As far as going to the legislature, I believe the bench meets with representatives now. I don't think that there is an issue with that. If you're talking important issue, not an issue that you personally may have with a law or something like that, and I agree with Tom that it is not the judiciary's role to legislate from the bench.
May I have my 30 seconds?
You may.
Upon further reflection, and in light of what Tom and Karen have said, I can see there would be issues of a very general, sweeping nature that a judge might want to bring to the community. I happen to know a judge who did a very good job of bringing to the community the issue of truancy, and that was an excellent issue. When you start to get more specific, that's when I start to feel uncomfortable. For example, abuse, the minute you start to say we need to shore up our abuse laws, you start to sound like you're thinking that everybody who brings an abuse action is in fact entitled to one. And so I think it depends on how general or specific.
Time. That's fine. Scott, a question for Carl, because Neil had to.
Thank you.
Carl.
So it seems that we're doing pretty well on time here, so before I ask this question, I'm going to put a little plug in. The York Daily Record is videoing this session, and the session will be shown in its entirety on our website. So if you might want to share that with folks who couldn't be here tonight, we'd like to just let you know that it is going to be there. So what are your views on whether the court as a whole deals effectively with racial, gender, and sexual orientation bias? We're beginning with Carl.
If I heard the question, Greg, you're saying what the court as a whole?
I'll read it again. What are your views on whether the court as a whole deals effectively with racial, gender, and sexual orientation bias?
Well, I think we discussed what the responsibilities of the judge are with regard to the administration of justice, both on the civil and criminal side, and that is to administer justice in a fair and impartial way. Obviously, fairness requires that that judge not reflect or demonstrate any kind of bias and not allow for the manifestation of any such bias in those proceedings. The court as a whole, that's the responsibility, and it's the responsibility of each judge to assure that that is how the administration of justice is administered. It's very difficult for me to say that the court as a whole does not adequately deal with it. Obviously, there are issues before the court at times that call into question issues of race bias. I mean, there are types of cases, employment discrimination and certain others, where these issues are implicated, and the court may be involved in litigating those matters. Obviously, to the extent that when you talk about equal protection of the law, the court is to administer the law and to administer the constitutional provisions that provide for equal protection under the law, such that its proceedings and the decisions that are made are appropriate and consistent with the constitutional provisions, and particularly with regard to disposition of those matters where the rights of individuals in those what they call suspect classifications under constitutional law arises. Racial classes.
Okay. Mike.
I think to start with answering that question, I think you first have to recognize that everybody has certain biases, that nobody is a blank page when it comes to biases. As a judge, I think, or the court system as a whole, you have to recognize when those biases exist and keep those in the back of your mind so that when a particular circumstance comes up, that you know that a potential bias could creep in. So, for example, I think, an area that you need to be careful with when I was dealing with juvenile delinquency matters are you treating a kid from Dover the same as you're treating a kid from the city for the exact same crime? And I always try to keep that in the back of my mind, where the probation officer is recommending the same type of placements for those types of kids who are committing basically identical crimes. I always tried to keep that in my mind when I was on the bench. No system is perfect because our entire judicial system is made up of human beings. But I think what we can do as judges, and certainly all attorneys and probation officers and caseworkers, is to recognize those potential biases and keep those in the back of our mind so that when we act, we're acting fairly.
I think over the past 21 years, I've seen a lot of changes in the law with regard to some of these issues. I think I argued one of the first same-sex adoption cases to Judge Euler many years ago. I don't know how many, but it was a lot of years ago. And the law in that area has changed significantly since I did that first case. And we really look at it from the children's perspective. I think we were trying to figure out how we applied the existing law to some new types of cases. Back then, the forms for adoption, said wife, husband, and it was kind of assumed that anybody adopting was married. Certainly that's changed. When I first started, I chaired the Women in the Law section for the Bar Association. We were very involved in changes in the rape law that had occurred 21 years ago. We made a lot of changes, or the legislature was making changes, not the judges, but the legislature was making changes in that area. But the women's section of the bar did a lot of pro bono work for victims of domestic violence. Now we really do a much better job representing them. The laws with regard to fathers' rights in custody cases have changed, and we're really doing a good job there. The laws with regard to paternity have changed as we've advanced with technology, with paternity testing, and those laws have changed. Judges just apply the laws. I think the more we change the laws to address those issues, the more we will have available to us as judges to do.
I'm pleased to say that in York County we have a very good bench right now, one that we can be proud of, and I have not personally observed any of our bench display prejudice or bias in these situations. Now, I'm also not naive enough to believe that these sorts of things don't happen. I know that by human nature, as much as I try not to be biased or to have an unfair perception, those thoughts creep into our minds, and we all have to be mindful of that. And as a judge, you need to be particularly mindful of that. And if for some reason you think that you can't be, then it's your obligation to hold your hand up and say, I can't preside over this case. One place that I think that we can pay particular attention in terms of procedure has to do with jury voir dire. So, and for those of you who don't know, that's the process by which a jury is questioned, a jury pool rather, is questioned in order to determine if they can be fair and unbiased in rendering a decision. So one of the areas that we can work on is when the court asks those questions to the jury, if any of those issues are at play, to be sure that we are getting fair and unbiased jurors deciding someone's fate.
Absolutely.
Well, we've talked about inherent bias in individuals, but I think it's important for us as judges, and I obviously hope to be elected and become a judge in York County, to recognize that it's always, at times it can be an institutional bias that has a disparate impact on segments of the community. When I look at the statistics, the criminal docket of the court, we have over, and the statistics I saw for the end of 2013 indicated that there was over 13,000 pending cases. 70% of the cases are plea bargain. Another 18% are handled through ARC referrals. So if one population is disproportionately impacted and forced to accept a plea, which results in disproportionate penalties, particularly felonies, you can see that there's an institutional bias that we have to be mindful as well. And I just want to raise that point.
Okay, anybody else on that? All right, go ahead.
Do I get 30
Yeah,
seconds?
absolutely.
I think this is an area too where it's not just justice but the appearance of justice. And out of the 15 judges, we were up to 4 women. We're back down to 2 women. And I do think that if you're looking at gender bias and racial bias, I think that the makeup of the court is something that should be a factor that people consider when they're making their selections for judge.
Okay, I get to ask the last question, and here's the new rule. We have a new rule. I know I'm going to use. I'm the judge here. We get a new rule. Sorry, Judge. Victoria tells me we have some time left, so I'm going to ask a final question. I'm going to start with Kathleen, and we'll move the opposite way. And then if there are an audience question or two, we'll take them. And the way we're going to do this, it can be addressed to a general question for all of you or individually, but everybody gets a chance to respond if you want. We're going to be completely fair about this. You all follow that? So here's originally I asked you a question about qualifications, whether you thought you were qualified, but I think it's really appropriate to ask the question, why do you want the job? And why now? In your professional and personal lives. Go ahead. We'll start with you, Kathleen. And you got 90 seconds, I'm sorry. Add that.
A lot of, almost all of the judges who have started on the bench in the past 20 years have started in family court. And we've talked about how judges can mentor attorneys, but sometimes the more experienced attorneys also have to mentor judges if they're starting on a bench in a field where that judge may not have a lot of practice. I think because we have been short on judges and we're likely to continue to be short on judges with additional retirements, it is important that the judges who come in have a really fast learning curve. And I feel that I can come into the court at this time and do a really good job for the citizens of York County, the families of York County, knowing the law that I have been using in the courtroom for the past 21 years to apply it to the cases fairly and efficiently, so that you're not getting cases coming back on appeal because a judge may not have the experience they need coming into that particular court.
As to why I want the job, I'm currently the county solicitor, and I get to work on a lot of broad issues that I think are pretty important to all the citizens of York County. But when I was on the bench, I really had the opportunity to work with individuals and in a meaningful way. Just as one example, I had a kid who kind of bombed out of drug court. We gave him chance after chance, and finally we decided we had to place him. And we decided to place him at Summit Academy, a place that I had visited and was comfortable with. On the way to Summit Academy, he tried to escape through the restroom at the turnpike. So I was quite surprised sometime later when I hear this voice saying, "Judge Flannelly," on the streets outside of the courthouse. And it was the same young man actually thanking me for sending him to Summit Academy. He had gotten his GED, he had straightened out his life, he was clean. And that's not the kind of thing you get to do every day when you're reviewing a contract for the commissioners. There's obviously a lot of different highs and lows when you're on the family bench. For example, I had a kid who graduated from drug court, did great for a year, and then was found dead on his mother's couch from a heroin overdose. But these are the types of issues that I feel competent to get involved with, and I look forward to that if I'm elected. Thank you.
Well, having practiced over 30 years, I would say that, becoming a judge is something that was a professional goal of mine at some point in my career. I came home to York by choice, and I wanted to give back to my community in many ways. I've done that through my voluntary service in the community. I've tried to serve as a role model within my own community in York in a positive way. I want to give back. My wife and I recently had dinner with one of the sitting judges and his wife, and I asked him, what is the most important quality you have to be effective as a judge in York County? And, obviously he said I had that quality, but he said, "Carl, it's temperament. To be effective, you have to have the appropriate temperament because of the different types of matters, different kind of people, the complexity, other issues that you address in a courtroom. You must show a certain compassion. You must show a certain dignity and respect for the people that come before you. And if you can be even-tempered, you can effectively do that, no matter what you have to deal with in that courtroom. So I believe that I'm at a stage in my career where I have integrity, I have experience, broad experience. I think broad experience is what's needed on the court as well. As Judge Euler indicated, you're not necessarily going to be in one particular court or the other. But I think in terms of the administration of justice, having integrity, broad experience, and having the appropriate temperament is important. And I believe I have those qualifications. And I think I can serve the citizens of York County well as a judge.
Neil?
My law partners asked me that exact same question when I told them that I wanted to run for a judge. They said, "Are you out of your mind?" And they said, you've worked 20 years to build a practice, and you're here, you're at the peak of your career in a prestigious firm, and why in the world would you want to give up all the benefits that go with that? And then they told me, they said, "By the way, no, you've never been involved in politics before. Just so you know, this will be like standing on a table with a blindfold on while people take whacks at you." They were right. It's exactly like that. But the answer to the question sounds hokey, but it's true. And I believe that we are each called upon to act in our lives in a way that improves the lives of others in our community. This community is critically important to me. It's where I live, it's where I work, it's where my children go to school, it's where I go to church. And I believe that this is the way that I can give back. And that's difficult. That means walking away from people I've worked with for 20 years and the spoils that go with that. But I believe that with the knowledge I've garnered and the experience, I can make that difference. And I have a good example. I was surprised tonight when my grandmother walked in, and she taught kindergarten in Red Lion for 47 years, and I watched how many lives she touched on a daily basis. People come up to me all over the country and tell me what a difference they made if they had her for kindergarten. I would like to be able to impact people's lives on that broad a scale and in that way every day.
Thank you for that question. Many of you know that I call myself a Christian. To me, that does not mean a Bible thumper. To me, that means that I go through life recognizing that the person who's homeless or the person at the rescue mission, that there, but for the grace of God, go I. I have what I would call a gift of empathy. I can really look into the eyes of the abused wife and see how that has just stripped her of all self-esteem, all ability to get a job. I have that kind of empathy. I love people, and I love trying to help them. That is why I proposed that if I'm elected, I'm going to try to convince the other judges into having a system of one family, one judge, like they have in Lancaster County. We have 6 family law judges in York County. Lancaster County has 6 family law judges. In Lancaster County, they'll divide the alphabet up into 6 segments, so one judge has each segment of the alphabet as determined by the last name of the family. So one judge has that family through abuse, protection abuse, through child custody, through support, through divorce, through property distribution. The judge gets to know the family. The judge gets to know the unique problems of that family, the unique problems of the children. I love children. I want to help children. I want to help families. I think I can do that with the empathy that I have and with this system of one family, one judge.
I'm going to try to stick to the question, which is why I want to be a judge. I love York County. I've been here for 43 years. I want to continue to make York County a better place for all of us that call York County home. I have worked my entire life in public service. I have worked in the trenches. I have worked as a caseworker, a probation officer. I have been the only female advisor to the quick response team in the York County Drug Task Force. And those are some of the toughest police officers that you will see in York County. Murders, arsons, drug deliveries, robberies, those are cases I have prosecuted. Those are cases I now defend. Child support, child custody, adoptions, wills, those are cases I handle in private practice. Your next judge needs to be able to get around a courtroom, needs to know the law, and needs to know procedure. I have experience in all of those areas, not just as an attorney, but as I indicated, working in the trenches. So that is why I want to be a judge, coupled with the fact that many years ago I saw Judge Thompson try a homicide case in York County, and I was hooked from that moment on.
Well, since my days at the DA's office, I've always prided myself on working closely with the defense bar to fashion an appropriate sentence for an individual that would come through that would get that person to the help and treatment that he needed. You can always see the person that comes through, you can take a look at their criminal history and determine what exactly it is that's fueling this behavior, and you're able to structure a sentence that will get that person to the help, the exact help that this person needs. And so when I got elected to the magisterial district judge bench, I realized that when a person comes before me and is clearly exhibiting these sorts of problems and these sorts of behaviors, it's very difficult at best to steer that person into the resources that will be able to provide him with the help that he needs. As a common pleas judge, you have the ability to steer those folks to the help that they need. My career has been defined by service to my community. I want to continue that service with your help as a common pleas judge.
Thank you. Okay, here's what we'll do. Can I have one of those microphones? I'll take the microphone. Oh, you're going to do that? All right. I didn't have to play Jerry Springer here. You can go down and do that. Would you please give your, put your hand up and then stand up. We'll get the microphone to you and give us your name. And if you have a question, now's the time to ask it. You all being bashful? How about any of the panelists? Oh, here's a question right there. Gentleman right there. We'll do one or two.
Obviously, the candidates all have different ages.
Yeah, go ahead.
And in York County, the Court of Common Pleas judge serves for a 10-year term. I'd be interested to know how many of the candidates can serve a full 10-year term.
You want to show hands? Anybody want to respond? Go ahead, Chris.
And there is in front of the legislature and soon the voters an amendment to the Pennsylvania Constitution that will make the mandatory retirement age 75. That is almost certainly going to pass. It has passed in many of the other states of the United States. And I would be able to serve an entire 10-year term and then some when that passes.
Anybody else want to comment on that? You all right? Any other? Go ahead.
Actually, the amendment, I believe, it needs to go to the Senate and then pass in the House again and then be put up for a constitutional amendment. It will not be on the ballot this year, and additionally, it has not passed in most of these states. It has, in fact, failed in most of the surrounding states.
Okay, there's a question back there.
Hi,
Your name, please?
Jennifer Kirk.
Thank
Actually,
you.
I've been to multiple forums, and there seems to be a theme that comes up about individual faith. I'd like to know how your religious faith will affect your decisions on the bench.
Is this a question for everybody?
That's a question
Okay, we started here with the final. Let's go back there and we'll go this way because you started it correct on the sum. Okay, go ahead. Is that on?
I am a member of the First Presbyterian Church here in York, and I have been so for many years, and I'm not ashamed at all to tell anybody who asks or anybody who wants to know that I am firmly a Christian. And you cannot separate yourself from your faith. Your faith is part of you. Your faith defines who you are. And to ignore that, you can't do. That makes you an imperfect Christian. And so, of course, it will factor in to my thinking as well. Because we all want to be fair. We all want to be impartial. And I believe that that is much of the lessons that we learn in our Christian beliefs. That is what I've been instilled with over the many years that I've gone to church. There's a reason why we do that. It nourishes our soul and replenishes what we have lost and reaffirms our faith in mankind. I think it's very important to have that part of you as a judge.
Yeah, you have to pass the microphone.
As far as my background, I'm a fourth-generation member of Union Lutheran Church, which is located in York City. I've been active in my church throughout my life, youth choir, reader. I served on the church council, and I also taught vacation Bible school and Sunday school, which may surprise some of you. So as far as that goes, Tom is right in that your faith does shape your life. I was brought up in a very religious household. I don't know that my mother's missed a day of church in her life. I don't profess to be that religious, and I do miss Sunday services, but I try to live my life according to my faith in the way that I was raised. And I do agree with Tom that I think that that will affect and does affect the decisions that you make in your everyday life.
Chris?
I'm a member of Providence Presbyterian Church, PCA. I've been an elder there since 1990. I've been active in the Susquehanna Valley Presbytery. I was moderator of the Presbytery, been active in the General Assembly. I think my faith would bear on my qualifications as a judge very, very much. I'd just like to add to what has been said. Fundamentally, I believe as a Christian that every human being is made in the image of God. Every human being is an image bearer of the God of the universe. Whether he or she has Down syndrome, whether he or she is whatever color or whatever economic status, every person is made in the image of God. My wife and I had a daughter who was cerebral palsy. I know a lot about disabilities. I've been active in Bell Socialization Services. Fundamentally, every person who would come in front of me would be treated as though he or she were made in the image of God, because they were made in the image of God. And that's vital to me. I believe in the traditional Judeo-Christian ethics that this country was founded on. I believe a lot of our problems in this country is that we've gotten away from that, and that families are crumbling, and that families are crumbling is why I want to be a family law judge if at all possible. I repeat, I love people, I love families, I love children.
Yeah.
I am proud to say that I am a Christian man of faith. Ironically, three of us up here, Tom, me, and Mike, all attend the same church, First Presbyterian Church in York. We actually have a committee. You know, you got finance and buildings and grounds. We have one called Running for Judge. But in any event, I am a Christian and a man of faith. I am certainly a flawed one, no doubt, and it has been a big part of shaping who I am, my values, and the things that I believe in. But here's what we have to get to. You have to get to the fact that there are going to be laws and decisions that are going to have to be made by a judge that may be inconsistent with things that you believe as a Christian. And when you take the oath of office, you're going to have to put your hand, I hope it's me, I get to put my hand on the Bible and say that I will swear to enforce and defend the constitutions and the laws of the Commonwealth. And I had to do a lot of soul searching in thinking about running for this job, whether I can do that. If I'm going to swear to do that, swear to God that I'm going to do that, and I have to enforce a law that's inconsistent with what I personally believe, I'm going to do it.
Well, I'm not a member of that church, but I'm a member of the Wheatfield Church of the Living God out on Wheatfield Street, which is my family church. My mother's here. My wife is also a member of the Church of the Living God. I teach Sunday school there, and I do sing with the men's choir there. I'm a Christian man, and I've been saved over 10 years now. My wife and I are both saved. You know, the way my faith would affect me is not so much whether or not I would be conflicted in performance of my job as a judge. My faith, it manifests in how I conduct myself and how I live my life. I read the scripture to mean to try to strive to live my life according to the commandments of God. And one of the most important commandments, as reflected in the scripture, is to love thy neighbor as thyself. That's how I try to live my life. That's an important commandment. That's how I live my life. That's how I will conduct myself, not only in the interaction in the courtroom, but outside the courtroom. And my faith will certainly guide me as a person, and I will strive, although I'm imperfect, just as everyone else is, I will strive to live my life as best I can as a Christian, following that commandment.
Certainly, my faith informs me in my practice as a lawyer, as well as when I was on the bench. As was mentioned, I'm a member of First Presbyterian Church. As I look out into the audience, I see a few more of you out there as well. I've served as an elder twice. I've been a Sunday school teacher. I've been a youth group leader for a number of years. I married the daughter of a Presbyterian minister and the granddaughter of Presbyterian missionaries. So faith is a significant portion of our family's life. Thank God I don't sing in our choir. I think that's something our choir director would be very grateful for. But I think I found as my time on the bench that, and I heard one of the appellate judges say this, that they pray that when they took the bench that justice would be done, that they would be an instrument of justice. And I think that's probably, the most significant thing you can do before you hit that bench is you make that prayer. And I've done so. Can't say I did it every time, but there are many cases where you just looked at the file and you knew that you were going to need help above and beyond what simply was contained in the pages of that document.
Thank you, Catherine.
I've been a lifelong member of St. Patrick Church, Catholic Church in downtown York. I did sing with the choir and was a cantor in my church, although I'm not doing that now. And I will say to Mike that our choir director used to tell us, whatever voice God gave you, give it back. So, just a word about that. I think that my faith affects how I deal with people on a daily basis. But as a judge, you have to apply the law. You don't get to put your personal preferences in that. As a Catholic, there have been very dark times in our church when Catholics were persecuted, and there have been very dark times in the Catholic Church when we were the people doing the persecuting. And I think all of those were dark times for the church and certainly informed the reason why we have separation of church and state. So I don't get to substitute my religious views for the law. My job as a judge in this world is to apply the law, which is based in, let's face it, Judeo-Christian values. But whatever the law is, that's what I have to apply. But I do think that it affects how I deal with people and how I try to respect people on a daily basis.
Thank you. We're going to call Andy up here to leave us with a few parting words. I traveled across the river, not to start the War of the Roses tonight. I'm not going to do that. Restart it, I should say. But I want to congratulate the panel on a high degree of professionalism and the intellectual quality of this evening's debate. And I'll turn it over to Pete. Go ahead, Chris.
Well, thank you to everyone for coming tonight. We hope that this has been informative and thought-provoking for everyone. Want to first and foremost, again, thank the candidates because that's why we're really here, and they put a lot of hard work into these campaigns to get to this point. I also want to thank our panelists who were asking the questions and the time and effort that they put in developing the questions and being here tonight, as well as our timekeepers who did a wonderful job keeping everyone straight and on time throughout the night. And lastly, we want to thank Terry Madonna for being here and assisting us as the moderator tonight in this program. And we actually have a small gift to give to you, Terry, for being here. And finally, we just want to remind everybody.
I have to give a little commercial. What you have there is something to celebrate Law Day, which is May 1st. We'll be celebrating that here in York on May 4th. but it is a commemorative coin in honor of this year's theme, which is the 800th anniversary of Magna Carta. So please enjoy that with our compliments and our gratitude.
And I have to add one more plug that Judge Euler asked me to put in when we started tonight, and that's that on May 21st, there's a regional truancy summit at York College that will be going on all day, and this is a program that's put on in partnership with the United Way and the York County Bar Foundation, and Judge Euler has been very instrumental in this over the years in bringing this issue to the forefront and making progress in our county on it. So with that, the last thing is just to remind everyone that May 19th is the primary election, and we encourage all of you to come out and vote. We've got some very hardworking and very qualified candidates here, and it's a two-way street. It takes the voters to elect them. We also want to encourage you to encourage others to vote, to get the vote out. Thank you, and have a good night.